Welcome all of you to our first Life Science Careers Week event today. This is one of several sessions taking place this week and the first of our Spotlight on sessions focused on patent law this afternoon. We're very excited to welcome our guest, Jonathan Lam. He works for Carpmaels and Ransford, and Johnny will be sharing a kind of fuller introduction very shortly. My name's Lucy Romain. I'm one of the careers consultants here in the Careers Service, and I'll be chairing the session today. And the first thing is to hand over to Johnny for a bit of an introduction and to tell us more about your career path and journey into patent law.
Great, thanks, Lucy. Yeah, I'll kick off. Like Lucy said, I've come from studying at Cambridge, and I had been at Cambridge for a while. So I started my degree, I think, back in 2013 in natural sciences. Stayed on for a master's until about 2017, and then started my PhD in the same year, finishing that in 2021, at which point I started here. I think I knew that I wanted to stay in some sort of science-based career. I'd always liked science and staying on for the PhD, but I think during my time at the PhD and even before it, I guess I was never completely sold on staying in research, either in academia or in industry. And so I was always keeping my eye out for other roles and other opportunities. And actually the Careers Service was organising one of these events with someone a bit more further along than me in the profession, actually, but was really useful to hear about other options. And I started applying, I think, a year or two before I finished my PhD and managed to secure a place. So that's kind of a quick summary of my route into the job.
Thank you, Johnny. That's a really nice introduction. So in terms of kind of where you're at now, tell us a little bit about the role that you're doing at this stage and perhaps what a typical day or week in your life looks like at the moment.
Sure, yeah. I guess I should emphasize that I am still quite junior. So I've been in the job now, would be just over 2 years. And I think one of the things to remember in this job is you really do start off being quite junior. So until you're qualified, which typically takes 4 to 5 years, there's a lot of things that you kind of need to learn from scratch. There's a lot of discussions you need to have with your more seniors because you're just not aware of how anything works, really. So yeah, just to put that on the table first. But my typical day, I guess, get in the morning, or sometimes we work from home. I think most firms now post-COVID are offering some sort of hybrid type work. Check emails. We normally get quite a lot of emails overnight from clients or internally that you need to look at. And one of the other main things is that there's a lot of deadlines that we need to deal with, and it's kind of quite fixed. So the patent office or clients will set deadlines for you to do things. So we have our own lists of deadlines. We have people to generate those lists for us. Most of us have internal lists as well to keep track of all these deadlines. So yeah, that'll be the first point of call, checking where you are with deadlines, if there are any new communications that have come in that you may need to deal with urgently. And then I guess to give a more general overview of the type of work we do, obviously within patent law, you work on patents, but there are many aspects to that. I think one of the main things that everyone gets involved with is what's called patent prosecution, which is essentially going from the application to getting your patent granted, which can be quite a long process of a few years. So there are always many of those cases ongoing, and that essentially involves you filing your application. The patent office will do a few checks, and then they'll tell you why. Well, they'll normally tell you why your invention isn't quite in the right state to be patented yet, at which point we start thinking about what changes we can make to it, how we can argue against it. And that's really the bulk of the job, is kind of arguing or discussing with the patent office, trying to get our invention protected. And as part of that process, obviously, you need to talk to the clients who are instructing you so that they're happy with what you're doing, they're happy with how you're arguing, all of that. I guess prior to that stage as well, it depends a lot on which firm you're at as to the type of work you get, but drafting the patent application itself before you actually file it is also another aspect of the work that you might be involved in. And then once the patents are actually granted, there's the whole contentious aspects of patent law. So you might try and knock out someone else's patent for various reasons. They might, other parties might try and knock your patent out for various reasons, and you have to defend it. And those things are typically a lot more involved and take a lot more time, and generally are things that more senior people would lead. But as a junior, you also get the opportunity to be involved with those. I think that's a quick summary of the types of work, but in terms of the actual day itself, it's maybe an hour or two a day in meetings. So those will be meetings with supervisors to discuss the plans, discuss your ideas, and really formulate what you're going to do to argue against the examiner or to email your client, that kind of thing. And the rest of the time, it's just you thinking about that before you go into the meeting. So obviously, you're expected to look at the correspondence that's come in, think about it, think about how you might argue against the particular objection that the examiner's raised. And then you're not expected to be right at all, really, at the start, but you should come to the meeting with something. And then, yeah, that kind of makes up the in-between time.
Excellent. That's a really helpful overview and insight. And I guess for those in the meeting today who aren't as familiar with patents and why organizations might want to patent an invention, can you just give us a bit of a brief overview as to perhaps why patents are so important to your clients?
Yeah, I guess from a basic level, the patent kind of allows you to stop other people from using your invention. So if you come up, or your client comes up with something particularly inventive and they've invested a lot of time and money into that, then as a way to kind of recoup their investment, they want to be able to make their invention, sell it, market it, whatever. And then if someone else were to come along and look at it and, I don't know, be able to reverse engineer it, I guess the patent system is there to make sure people don't do that. So the person who's actually put the time and money into getting their invention can reap the rewards of their inventiveness, I guess. So yeah, that's kind of the overview.
So it's protecting organizations' inventions so they can really get the best, usually profit kind of benefit or market
Exactly.
out of it. Absolutely. That's really helpful. Thank you. And what would you say are perhaps the most challenging aspects of both your role and perhaps, you know, that you mentioned the long training process as well, so perhaps the combination of challenges of the training and the role itself?
Yeah, I mean, I think that's definitely one of the more challenging parts. I think I'm coming into the proper exam season, but it is difficult to kind of juggle doing the job as well as doing the exams at the same time. Obviously, everyone is aware that certain people are doing exams, but at the same time, they also think that everyone is quite capable of doing both at the same time and spending time outside of general working hours, revising for exams and doing all of that. But I think that is one thing to note. I never intended, once I'd done my master's, to have to do more exams. So it is something to be aware of, that you will have to do quite a few exams in order to become qualified. I suppose challenges beyond that, the number of deadlines you also have to deal with is quite a different way of working, I think. At least coming from a PhD background, obviously your supervisor will be keen that things move on as quickly as possible and you try and get papers out and publish. But it's almost more focused. You may have a few projects ongoing, but here that you have quite, I don't know, tens or hundreds of things going on. They won't all be at the same time, but you will have to organize your time quite well to make sure that deadlines don't get missed and supervisors are happy, which I think is more of the the important one, because deadlines generally don't get missed because someone will really bother you if something is going to be missed. But it's more just within the firm itself, making sure that you are on top of things and everything is done on time so that people have time to look at it. I think for me personally, coming from a PhD where I've been very particular in the supervisor that I'd chosen, one of the things that I had found a bit more difficult was also getting used to how other people work. I think I have, as I know, 10 or so supervisors here, and there are some people who I just naturally get on better with than others. And I think that will vary between firms, but certainly here, you don't really get much of a choice in who you choose to work with. And so it's also being able to be a bit flexible in terms of how people like you to work with them, how they want their work, that kind of thing. Not necessarily a problem for everyone, but just something to be aware of.
Yeah, that's some really interesting reflections on a broad range of things that can be challenging, and give some insight into the kinds of skills that are quite important in patent work as well. And you mentioned see, it's a fairly long training process with exams. So could you just briefly outline perhaps what that looks like for you, and kind of, I guess, whether there's kind of flexibility in how you approach that process within your organization?
Yeah, I think as I said, or as you said, my firm might do it differently to others, but I think as a general rule, if you're training in the UK, everyone will want you to be European qualified, and most places will want you to be qualified in the UK as well. And my route to qualification, I think you start in September, you have more or less a year, and then the next September time, we're sent to do it's a short diploma course, I think, at one of the London universities, which lasts from September till January, where you have exams. And that course is designed to basically train you up in the basics of all intellectual property, not just patents. And I think also helps exempt you from some exams that you need to do. Other firms, I think, will prefer you to take those exams instead that I just said are exempted from. And then March time, which will be my March coming up now, there'll be the first set of European exams. And then September, there'll be a second set of UK exams. The following March, there'll be the final set of European exams. And then the following September, there'll be the final set of UK exams. I think there's a bit of flexibility at my firm, at least with regards to the UK ones, because actually we don't do that much UK work. It's more European work. So I think the UK exams are a bit more flexible in terms of if you want to delay them a bit, you can. But the European ones are more or less set in stone that you do need to do the ones in March now and the ones in March next year. And another thing to note is the fail rate actually for the exams is relatively high. So it's not that surprising that people will fail papers and have to resit them, which I think is, again, a bit different to how we're used to doing it at university.
Yeah, that's really helpful. Thank you. And I think that gives a bit of an insight into kind of the structure of being a trainee for those who are thinking about this career path. And you mentioned that high failure rate. What are the implications of that for you in your role if you do fail an exam? Because obviously you mentioned it is quite different to being at university.
Yeah, I think there are some sort of legal things so that if you're not qualified, you are restricted in some actions that you can do, but by and large, they don't prevent you from doing the job too much. It's only very specific things like being able to speak in what is essentially the court of the patent office, which obviously when you're qualified and you get more senior, you do need to be able to do that, and clients will expect you to be able to do that. So it will stop you from doing those sorts of things. But I think it's generally regarded that you pick a lot of experience up just doing the job. So you actually failing papers it doesn't necessarily seem as negative as it sounds, in that you're still very capable of doing the job, but it's just a little bit of a barrier that you need to pass to be able to do a few more things. And I think generally firms are quite good at, if you fail once, even twice, like making sure that you're supported and you don't necessarily, I don't know, get looked down upon or anything like that. But yeah.
I think that'll be very reassuring and helpful for those listening to hear about that, because it's certainly quite a different culture with professional qualifications compared to perhaps the university experience. So I think that'll reassure a few people, because it can be a bit disconcerting to hear about, lots of exams with potentially quite high failure rates, to know that the implications day to day in your job, there are opportunities to resit them and support that's put in place as well. So that's really positive. So we've talked about the challenges, but tell us a bit about what you find rewarding in your role, and maybe it might be nice to comment a bit on perhaps how you feel you use your scientific background in the work that you do as well.
Yeah, sure. I'll probably take the second question first. I think the science stuff is one of the main reasons why I decided to move into this, just because I had always wanted, and I appreciate now, the opportunity to kind of broaden the topics that I work on. I think especially doing a PhD, obviously it's part of it. You become an expert in one very small field of something or other. And I think it's nice now to be able to apply my science to many different types of invention. And I think, yeah, that's something that I do enjoy quite a lot, and being able to engage with lots of different topics, and often quite suddenly, I guess. Like, often you'll be asked to help out on something that you haven't looked at in a while, and you might not have a lot of time to look at it because you've got other things to do, or because the supervisor or the client doesn't want you to spend that much time on it. And I think it's nice to be able to get engaged with all those different things. I think I also like the problem solving aspect of it. Obviously there's problem solving in a lot of jobs, but I think this one in particular, you are having quite direct discussions with examiners or other parties, and maybe your arguments don't work all the time, but it's nice when they do, to feel like you've actually achieved something within a team or on your own. And I think that feeling is something that I find quite rewarding. And I guess also from a client perspective, it's nice for them to kind of appreciate what you do. If you do win something quite big for them, or get a patent granted for something that they particularly want, it is quite nice to feel that there are people who appreciate what you do.
Yeah, it sounds like a great opportunity to apply your scientific background, but also stretch your knowledge as well across a range of different applications and inventions. So that sounds very exciting for those who want to stay connected to the innovation and developments in the field. Someone has posted a question asking about whether a master's or PhD is necessary or advantageous for moving into patent law. So would you want to share your thoughts on that?
Yeah, I'm just trying to think of people in my year. You definitely don't need a PhD. There are certainly a lot of people who don't have a PhD, no matter what the field is. So yeah, there are life scientists who have just come straight from masters, engineers who are the same. I think, just going off the numbers, I think if you've just come straight from an undergrad, I suspect it's harder to get a place, only because I don't know a lot of people who don't have a master's. I don't recall whether my firm or indeed other firms specify that as a requirement, but certainly you don't need a PhD. And I think I seem to remember from talking to one person who applied during their undergrad, they were told to do their masters and come back and reapply. So maybe that is at least some anecdote about needing to have a master's, but certainly don't take my word for it. Do look at the websites and see what they require.
Absolutely. I think it definitely varies from firm to firm, but if in doubt, we often have career fairs where you can come and talk to employers directly as well. So certainly if any of you on the call today are exploring this further, you can always have a chat to employers if there's any kind of lack of clarity when you have a look on their website. And just following on from that, someone's asked, is it common for more experienced scientists, such as those who've had a couple of years as postdoctoral researchers, to join as trainee patent attorneys? Is it more typical for recent graduates? And are there any advantages to having a bit more research experience?
I'd say it's more common not to have had a postdoc, but there are people who've done a postdoc, indeed at my firm and others, who come straight into the profession. I think in terms of it being an advantage, it probably starts tailing off a bit. I think they kind of expect everyone to have a strong understanding of science. I think knowing, at least for me, knowing like lab techniques has helped a bit to be able to read papers a bit quicker. But I don't know, maybe the undergrads working with me as well are already used to that, and it just took me a PhD to get that as well. So I think doing a postdoc won't necessarily give you a lot more than what you might have gotten in a PhD or less, but it can be helpful, and it's certainly not a barrier to applying or anything like that.
I think it'll be reassuring for any postdocs here today to know that people have made that career shift into becoming trainee patent attorneys and can use their science in that way. So that's really positive. The next question is around exploring firms. So maybe you might want to share what you thought about, but what sort of things should you look for or consider when choosing which firms to apply to? Are there any pros and cons to working for a bigger firm?
Yeah, again, I'll take the second question because it's a bit easier for me to answer, but I think the bigger firm is just more for me a kind of social thing. I think our firm at least has quite a big intake of new trainees, and I wanted more people so that we could go through the process together, I guess, rather than being on my own and having to go through exams and training on my own. But I think that's just more of a personal preference thing. With regards to selecting a firm, it's difficult because I think it's quite, at least when I was applying, everything was quite competitive, and I was recommended by a lot of people just to apply to as many as possible. I imagine some people will know that there's kind of like a tiering system based on some, I don't know, independent website or something that ranks firms based on, I don't know, client satisfaction or other metrics like that. And I think some people might prefer to work at a higher tier firm rather than a lower one, just because maybe of the sorts of clients you might get and the sorts of inventions that you might get. I think the kind of bigger, more well-regarded firms tend to have, well, the bigger clients, but that's not necessarily something that might appeal to everyone. So we don't really, or at least I don't really work with a lot of small inventors, which I've heard from other people can be quite fun because you really get to start from the bottom and talk to them more about the invention and how they might protect it. Whereas here often they'll have their own internal IP departments, and they'll just come to us more or less to outsource. So they'll already have an idea of what they want, and they'll just give it to us to take through. So I think that one varies a bit depending on what you're after, but probably apply at least to quite a few, I think, just to increase your chances if you do really want to get the job.
Yeah, that's really good advice. Think about what's going to work for you as an individual, and that will probably shape what you're looking for a little bit in terms of different firms. And I think that's a good stage to kind of mention that you can always reach out via LinkedIn to chat to people at different firms if you're not sure what a firm is like and you've got questions. I'm sure many people will be happy to have a short chat or give some tips and advice based on their own firm and experience as well, because there's definitely a bit of variety in the sector, isn't there? Another question has come in that is, I'm gonna stick to kind of entry points and then go to kind of work culture and what that's like. So someone's asked, does everyone applying for patent law come from a science background, and is that a requirement or an advantage?
Yeah, as far as I'm aware, everyone who applies to patent law has to be a scientist. I think a few people I've spoken to seem to think that you need some law backgrounds, but you definitely don't. You need to have the science background, and then they will just teach you the law. I think they value it a lot more that people have the ability to read and understand scientific inventions first. And indeed, when you are more junior, often your seniors will come to you to help understand the invention just because they've been out of the science for a while. And you just build up your legal knowledge as you go through.
Yeah, so I think it's worth highlighting the difference between patent law and working in intellectual property law as a solicitor or a barrister, which are two kind of very different professions that do overlap sometimes, I understand. But in patent law in particular, it tends to be scientists who then train to do the patent and IP work, whereas as a solicitor or barrister, it's an area that you can specialise in as part of your legal career. So Johnny, please correct me if I've got anything wrong there.
I think that's right. I mean, to be honest, my knowledge of IP solicitors isn't that great, but it sounded sensible to me.
That's good. And then in terms of kind of the recruitment processes, you mentioned applying to quite a few firms and being encouraged to do that. If you can remember, are you happy to share how many you applied to? And also, can you remember kind of the types of questions that you were asked or the types of assessments you had to do as part of the recruitment processes?
Yeah, I think in the end, I say only. I think I only applied to around 6 or so firms. I think my idea was that, well, firstly, I decided to apply relatively late in the application calendar, I guess. So I didn't want to spend too much time stressing about applying to many firms. And I had a feeling that some of them might have started their application windows a bit later. But yeah, I think 6 is relatively on the low side for what I've heard from other people. In terms of questions, at least at Carpmaels here, we had there's a kind of like general white space general questions that you would get to fill in on an online form that I guess they use for pre-screening, like CV, personal statement type things. And then once you get past that stage, I had 3 more stages. So the first one was a sort of pre-recorded video interview where questions would just flash up on the screen. You'd have 60 seconds to answer them. And those were very much scientific questions. So at least for me, from like a life sciences background, it was stuff like, how would you measure gene expression and things like that? And then you just have 60 seconds to answer it. So very much on the technical side. The second interview, I think they gave me a couple of scientific papers to read. So again, quite technical, that they said we would have to discuss with 2 people. I think I had, in the end, 2 partners at the firm. And I think there was also some sort of grammar correction type exercise. So they give you a document or an article and just ask you to point out where there were grammatical errors or things like that. And then the final interview was with all of the biotech partners at the firm, and that was a mix. I think I had to prepare a technical presentation on something that they'd picked out for me, but it was also some more questions about being a patent attorney and some questions to test how well I would discuss contentious issues. I think one of them was to do with whether I would make the COVID vaccine compulsory or something like that. They just want to hear like how you discuss points. So I think the last interview was just a mix of both.
Yeah, I think that's really helpful and insightful for those who might be thinking about making applications, to help them prepare for those processes. We've had a few questions around kind of the experience of working in firms. So one of the questions is around, what are your hours like and how do you find the work-life balance?
Yeah, I think as a junior, generally speaking, the hours are quite standard. So I'm pretty much 9 to 5. I think depending on the workload and the workload in general of the team, tasks might get assigned to you that might require you to work a bit outside of that. Like I've certainly worked, I know there's a period of a month where I worked most evenings and the occasional weekends, but that's certainly not the standard. I get the impression that, at least here, the more senior you get, the more you are expected to, I don't know, be constantly available for your clients. It's not necessarily that you need to work evenings and weekends. It's just that you need to be available if they want you for something, which may require you to work outside of hours. But yeah, I find it quite good, to be honest. Like as I said, I'm quite normally 9 to 5. I can work from home 2 days a week, so I find it quite a good balance.
That's good, and I'm sure very positive to hear for those who ask those questions. And one of the questions was around whether you feel there's sufficient study time during working hours for exams. So how do Carpmaels kind of support you around the exam periods?
Study time, I say this having only done one of the exams so far, one of the chunk of exams, and that was very much just like going to university for 3 months. We had to, I think we had lectures 3 weekdays out of 5 on that course, and one of the days was a study day per week. One of them we were expected to do a day's work. Again, that varies between firms. I knew other firms that just let them go off and spend time at the university and not really do any work. I knew firms that were saying you had to work more than 1 day a week. So I think that varies. In the run-up to exams, they will give you at least 1 day off before the exam as a study day. And I think it then varies on what the exam is. So the exam I have coming up in March is generally not regarded as being too strenuous. So they only give you 1 day off before, but you are expected to spend your weekends revising it, not every day at the weekend, but just doing past papers and making sure you're well prepared independently. We did have a tutorial organised, so they will organise internal tutorials or external people to come in and tutor us. I think for the harder exams, we are sent off on courses to learn about how to prepare for them, and then you may get more, I think typically like 2 or 3 days per exam off as study leave in the run up to that. But yeah, I think that varies a lot between firms, because with us, we're generally responsible for our own cases. And so even if you have days off, if there's a deadline coming for one of your cases, you'll at the very least have to tell someone else about it so they can cover it for you. Whereas I think at other firms, the level of responsibility when you're more junior is not quite as high. So it may not feel as stressful having to organize work on top of the exams. So yeah, I think worth just asking people at other firms if that's quite a concern to you.
Yeah, that's really helpful. And I think as you've highlighted, your experience may not be the case at other firms, but it does sound like that it does vary for different exam periods as well. So that's useful to get a picture of what that looks like in your experience. Someone's asked a question that says, in your opinion, are your managers in patent law prepared to manage people with an academic background? So I guess they're trying to get an insight into kind of perhaps the different management styles you've experienced, and you've mentioned there's been a bit of a variety, so it'd be good to hear a bit more about that.
Yeah, I mean, I'd say it's more of a personality thing rather than just being able to manage people from an academic background, because I think everyone comes from an academic background. It's more just that some people like things done in very particular ways, and I'd been used to controlling that because I'd always picked who was supervising me, and I'd always spoken for a while to them before. applying to their lab or whatever. I mean, people are very understanding at the start that you don't really know anything to do with the law, so no one is ever going to tell you off for getting things wrong. I think it's more just that, at least at this firm, you need to adapt to how other people work. And again, I think at other firms, you may just be given one or two key supervisors. And I think at another firm I applied to, they did tell me it'll just be me, or it'll just be me and this other person who will be giving you jobs, in which case some people might prefer that because you get to know them a bit better and you figure out how they work a lot better. But yeah, here there are many people.
Thank you. And I think we'll take 2 more questions before we start to wrap up for today. But someone's asked about the balance between opportunities for those from biological and life sciences backgrounds and those from physical sciences backgrounds, and kind of what your view was on that when you were looking for opportunities, and whether there were more in particular areas of or fields, or whether you felt that there was a good range of things out there.
Yeah, I think from looking at job adverts, at least when I was looking, it was pretty even. I think just based off my year, there are more people from the life sciences, chemistry area than there are engineers or physicists. But I think in terms of, our firm is organized into 3 main groups, which is biotech, which is the one I'm in, chemical and drug and composition type things, and then the engineering side. I think just by its nature, there may be more in the bio and chemistry, just because there are a lot more drugs around and biotech things around than there are engineering type things. But that might just be my firm. But I mean, I certainly wouldn't worry that it's a lot harder to get into engineering or something like that. I think it's pretty even across the board.
That's super helpful, thank you. And I think just as a final kind of question for those who are thinking about how to use their time whilst they're still at Cambridge, often when you look at trainee patent attorney job ads, they're quite skills based, but they don't ask for very specific experience. So have you got any sense of the kinds of things that you think either helped your application or helped you develop your CV, or activities you would suggest people kind of think about as evidence when they start thinking about applications?
Yeah, I guess I would never be sure as to what exactly helped me, but I think, as you say, they tend to get a lot of applications from people who are generally quite good. They have quite good marks. They've done quite well in their degrees. So anything you do that kind of shows you have some interest in, I don't know, the commercialization aspect of science and those sorts of experiences. I think I had previously done, I don't know if it still exists, but it was called like the Yes competition to do with young entrepreneurs or something like that. And I'd also done some medtech, or taken part in some medtech society or project during my time at Cambridge. It was never mentioned in my interview, but it may have helped distinguish me from other people. Who knows? I would say though, if hopefully you do get the interview, if it's something you want, it is wise to figure out, or at least have set in your mind, some sort of basic understanding of what a patent is and what the job entails. Obviously, I've given quite a broad overview, but one of my questions was certainly very heavy in terms of, it was a kind of a scenario where they said your client has just been sued for patent infringement. What would you do? And if I hadn't looked at anything to do with the job, I have no idea. So it's just something to be aware of, that they may quiz you on making sure that you've actually looked at what a patent is and the kind of basic legal stuff, I guess.
That's super helpful. And I think you're right, in Cambridge, there's a huge amount of opportunities to explore that entrepreneurial and commercialization side to get a bit more of an insight into that kind of emerging and new innovation technology space. So some of the resources I'll highlight shortly will help you to navigate some of that, but that can be a good way of showing that you've got the academic knowledge, but also have engaged with the kind of the other side, which you'll come across from your clients' perspectives in the role. So Johnny, that's been super helpful, and you've given such great insight and information about the role. Is there anything we haven't covered, or any kind of final tips or pieces of advice that you would like to share with our audience before we wrap up this afternoon?
No, I don't think so. Yeah, I'm hopeful that I've covered it relatively well, so that people are at least a bit more informed about the job and how to apply and whatnot. So
I think you've been absolutely fantastic. So thank you so much for taking the time to join us today.